If you saw my response as far as the person that needs the sign language interpreter, I did go ahead and speak to the court, and they're prepared to handle it tomorrow. So Ms. Robinson can be continued.
Okay, roger that. We wasn't sure yet, so we didn't get her, so we are good to go.
Okay.
All right, they're all yours.
All right, give me 1 second here. All right, ladies and gentlemen, if you would, my name is Judge Marcus Thorpe. It's approximately 11:02 this morning, and this is Clayton County Magistrate Court first appearance here. Again, I am one of the associate magistrate court judges here, and I've been requested, of course, to preside over your first appearance. Now, just briefly, I have a couple of things I want to talk to you all about before we get started. As I mentioned, this is your first appearance, and what that means is that for each of the individuals here, both ladies and men, you of course have been arrested for allegations you're having committed particular crimes. So what today's court appearance is about is my identifying for each of you what you have been charged with and what your total bond is. Now, please remember that this is not your day for trial, excuse me. And so what that means is if there are particular things that you want me to know that are not related to your bond, the best advice that I can give you is not to discuss those things with me here today. Now, please remember, because this is being tape recorded, there are witnesses here. The last thing that you would want to do is to say something that is going to harm you down the road as you work to the resolution of your case. And so again, I say that to please be mindful of that in the things that we discuss here during your first appearance. And by that, I mean, really and truly, the only things that we should be discussing are, in fact, your bond, how much your bond is, any special conditions, and things of that nature. Anything else, again, I would request that you hold that until you have had an opportunity to speak with attorney down the line. Now, as I mentioned to you, this is your first appearance, and those come with rights. You do have the right to remain silent, so that nothing that you say can, otherwise everything you say can be used against you in a court of law. You do have the right to an accusation or to an indictment. You do in most situations, especially if you are charged with a felony, have a right to a jury trial as well as a speedy and public trial. Now, as a part of your first appearance here today, in addition to telling you about your bond, I'm also going to discuss with you what are called special conditions. And what I mean by that is there are certain individuals of you who may have been alleged to have committed certain crimes that we have put into place special conditions. And what that means is you may not be able to have contact with a certain person. You may not be able to go to a certain piece of property while your case is pending. And let me give you an example. If you are alleged to have gotten charged with a battery, or an aggravated assault, or criminal trespass, or things of that nature where you're places where you weren't supposed to be, or you've gotten into a fight or an assault with someone, you may hear me tell you that you have a special condition this morning, which is to stay away from that person or to not go onto that property. Now, in those particular situations, ladies and gentlemen, please let me advise you that if I tell you you have a special condition, please, as best as I can tell you and emphasize to you, follow that condition until such time as your case is closed or that bond condition is modified. If you fail to adhere to that bond condition and you have contact with that person, either by telephone, email, in person, mailing a letter to them, however you so choose, texting them, it is a violation of your bond and you can come right back here and be put into custody. Same thing goes for being on a piece of property you're not supposed to be on. If I tell you here today that that is a special condition with your bond, and you end up on that piece of property again, that is also a violation of your bond. And again, it can land you right back here in custody for an additional felony charge and a fine of up to $10,000. Now, as we talk about your bond, ladies and gentlemen, there is also something else with respect to special conditions. When I give you your bond, each of you will have the ability to make your bond. I think there's only one individual here that was not entitled to bond based on their previous criminal history. And so when you're entitled to make your bond, there are three options, three ways, excuse me, that you can obtain your bond. One would be straight cash, so paying cash for your bond. And typically you would do that by, of course, paying the amount that I will tell you. The second way to do it is what is called a property bond. A property bond is where either you or someone you know brings into the deed of their property into the sheriff's office here in Clayton County, and they essentially put that deed up against your bond for your case. And so what that means is their deed comes to the sheriff's office holds on to that deed until such time as your case is closed, and as long as you attend all of your court-appointed appearances. Now, in order for you to use a property bond, the person who puts their property up for you has to have 3 times the amount of equity in their property as your bond is. So if your bond is $6,000, the property you use for your bond has to have at least $18,000 in equity. So 3 times whatever your bond is. And again, that deed to that property is held by the sheriff's office until your case is closed. And so if you do make that decision to use a property bond for a piece of property that belongs to you or someone else, the strongest piece of advice, of course, we can tell you is obviously to attend all of your necessary court appearances. So we've talked about property bonds, we've talked about cash bonds. There are also bail bondsmen that you can work with as well. Now, if you choose to work with a bail bondsman, typically a bail bondsman will require that you pay anywhere from 10 to 15% of your bond, and they will put up the remainder of it. So again, if we use the example that we've been discussing, $6,000 your bond, typically a bonding company will require that you put up anywhere from $600 to $750 and no more than $900 of that bond out of your own pocket, and then they will put up the remainder for you. So those are the 3 ways that you can make your bond. Ladies and gentlemen, please remember, if I give you a special condition and you are to stay away from a particular person, that person cannot come up to the sheriff's office and try to bond you out. So again, because you cannot have contact with that person, if you have a special condition to stay away from them, please do not contact them and tell them to come bond you out. If they come up here on their own will or their own volition, they will be turned away once it is determined that they are in fact the alleged victim in your case. Now, so we've talked about the way in which you can make your bond, how much your bond will be. As I mentioned to some of you, there is at least, I believe, one individual here that is not entitled to bond. And what I mean by that is, if you are currently on probation for a felony and you now have obtained a new felony charge, you are not entitled to bond, and I did not give it to you. And as I mentioned, I know of at least one individual in my review of this person's criminal history. They were not entitled to one based on their prior history. Now, ladies and gentlemen, at this point, we're going to go, I'm going to swear each of you in as a group. Then we're going to start with the ladies first here. Again, I'm going to announce each of the charges for each individual. As I give you your charges, I'll give you your bond amount. If you have any questions, I will do my best to try to answer those. But again, let's keep those questions limited to the discussion of your bond only. No discussion of your case should be had here this morning. So with that, ladies and gentlemen, if you would, if everybody would please raise your right hand. Do you swear or affirm the testimony that you're about to give here this morning will be the truth and nothing but the truth, so help you God? And if you do, say I do. All right. All right, if we could get the females up first in line, and I have up first Latanya Nicole Harris.
What, Your Honor, what about Tiana? Yeah, Tiana DeJeanette. She should be number 2.
Yes, I apologize. Think I might. Yeah, we can have her up first, Deputy. Just give me one.
We have on ours. Come on, Miss DeJeanette. We'll have a seat.
All right. Are you Miss DeJeanette?
I am.
Good morning, Miss DeJeanette. How are you this morning?
Good morning. I'm doing fine. How are you?
I'm doing well, Miss DeJeanette. So, Miss DeJeanette, you're charged with 1 count of driving with a suspended license. You're charged with 1 count of defective equipment, 1 count of tire restrictions, and 1 count of defective headlights. Now, in a review of your criminal history, ma'am, I want to advise you, your case is not being dismissed, but you will be released here later today. Do you understand that?
Yes.
Okay. Now, what that means again is your case is still going to be pending. And so I would advise you to make sure that before you step off these grounds today, that you are aware of the last known address the Clayton County Sheriff's Office has for you, because they will be sending your court appearance dates to that address. Do you understand that?
I understand.
Okay, now let me ask you this. I have here that you are earning about $1,000 a month. Is that correct?
Yes.
And do you have any children, ma'am?
Yes, I do.
Okay. Now, based on that, I am going to go ahead and appoint you a court-appointed lawyer that will assist you in your case. Now, you were charged with all driving offenses. Those are called misdemeanors. So you aren't necessarily entitled to what is called the preliminary hearing. I should have explained this to everyone earlier. Now, what a preliminary hearing says is when after your arrest and within 30 days, you're entitled to a hearing where the police officer has to come in, they review the evidence and determine, and a judge will determine if there's enough evidence in your case. Now, in your case, Ms. DeJournette, I want to advise you, you lose the right to a preliminary hearing when you get released, okay? So you won't have that opportunity to have that hearing. But again, please keep in mind that whatever your address is, make sure that they are aware of it here at the sheriff's office so that they are able to send you your court dates, okay?
Yes, sir.
Do you have any questions about anything, Ms. DeJournette?
I do not.
All right, ma'am. Well, that's all I have for you, ma'am. Good luck to you.
Thank you.
Thank you.
Ms.
All right,
Harris?
Deputy, next up, I should have Miss Latanya Nicole Harris. Are you Miss Harris?
Yes,
Good morning, Miss Harris. How are you?
good morning, I'm fine.
Ms. Harris, I reviewed your information this morning. You're charged with 1 count of theft by shoplifting. You do have one special condition on your bond, ma'am, and that's to stay away from this address where this incident was alleged to have happened at 7434 Terra Boulevard. Do you understand that?
Yes,
Now, after a review of your criminal history and the information alleged in this warrant, I'm going to advise you, you will be released here today. Do you understand that?
yes,
Now, that does not mean that your case is going to be dismissed. Your case will still be moving forward. And so I advise you that if your address has changed or is not what is shown on your license, that you do want to go ahead and make sure the sheriff's office has the correct address that you want your court appearance information sent to. Do you understand that?
yes.
So based on that, ma'am, do you have any questions about what I've told you so far? You have one special condition. You will be released today. However, you do have to stay away, as I mentioned, from that 7434 Terra Boulevard.
Okay,
Now, the last thing, just really quickly, ma'am, I see here that you're currently not working. Is that correct?
yes,
So I'm going to go ahead, ma'am, and appoint you a court-appointed lawyer. And so that court-appointed lawyer will be in touch with you shortly about your case, okay?
okay,
All right, ma'am. Well, that's all I have for you, ma'am. Good
Ms.
luck
Circle.
to you.
okay, same.
All right, and so then next up, I would have Miss Haynes Robinson, who has continued. And are you Miss Anastasia Circle?
Yes, sir, I am.
Okay, so Miss Circle, I have here this morning that you are charged with 1 count of battery. Your bond is in the total amount of $3,500. You do have special conditions, and that's to stay away from the alleged victim, Miss Michelle Stripling. You're also to stay away from the address 2254 Lanier Place.
Yes,
Ma'am, if that's where you live, I have checked on your bond paperwork that you may, if you make bond, obtain the use of the sheriff's office to go and get any items that belong to you there until this case is closed. Do you understand that?
okay, will I still be in here?
Well, that's going to be up to you, ma'am. Again, your bond is $3,500. So if you're able to make your bond and then you are released, you would then, you're able to go to that property, but you're not able to go unless you're with someone. Do you understand?
How long will I have to stay if I can't make my bail?
Well, that's going to really just be up to you and your
I have a
attorney.
guardian, I have a guardian.
Okay, unfortunately, ma'am, I can't tell you how long it's going to be. That's going to really be up to, how quickly your case is resolved. Okay.
Okay,
Now, so just a few other things. As I mentioned, you do have a stay away condition from Ms. Stripling and from the property. But also, I'm looking at your court appointed information that you filled out. Are you working currently, ma'am?
no, I'm on disability and social security.
Okay, so I am going to go ahead and appoint you a court appointed lawyer this morning. And then lastly, you are charged with a misdemeanor. What that means is, ma'am, you have the right to what is called a preliminary hearing. And that's where if you're still in custody in 30 days, you'll have a court date. And then the judge will listen to the police officer and they'll determine if there's enough evidence to go forward on your case. Now, if you make bond before that happens, you won't have the preliminary hearing. You automatically waive it. Okay. Now, you don't have to have this hearing if you don't want to. We can waive it. Oftentimes, people choose to waive that hearing because it makes their case move a little faster. Again, you have two options. I can sign you up for the preliminary hearing, or you can waive your hearing. Which would you like to do, ma'am?
I want to waive it.
All right. So I am waiving your hearing here this morning. Ms. Circle, do you have any other questions for me?
No.
All right, ma'am. So I believe that's all I have for you, and good luck to you.
Okay.
All right. Thank you.
Right.
I'm not there.
Okay.
Deputy, who do you have Ms. Upshaw next?
Yes, sir, Your Honor.
All right. And are you Ms. Chantrez Upshaw?
Yes, Your Honor.
All right. Good morning, Ms. Upshaw.
Good morning.
Ms. Upshaw, you are charged with one count of hit and run. And apparently there's no allegation of serious injury, however. Your bond is going to be in the amount, a total of $3,000. Do you understand that?
Yes, sir.
Now, Ms. Upshaw, this is a misdemeanor. And so therefore, as I was explaining to the individual before you, Ms. Circle, you do have a right to what is called a preliminary hearing, or you may choose to waive that hearing. And just to explain to you again what a preliminary hearing is, as I explained to her, a preliminary hearing is where if you don't make bond within 30 days, the officer's got to come in and the officer's got to show the judge what kind of evidence they have against you. Now, because again, you're only charged with misdemeanors, you don't have to have that hearing. And oftentimes people don't want to have it because it does slow things down a little bit with their case. So your options are you can choose to have the hearing or you can choose to waive the hearing, ma'am. What would you like to do this morning?
I'm gonna bond out, Your Honor.
Okay, but in case that you don't, I understand that you believe you will or you will, but in case that you don't, excuse me, would you like to have that hearing or waive that hearing, ma'am?
I don't have the hearing. But
You said you will?
having the hearing means that I'll go to court within 30 days. And if I waive the hearing, that means I'll go to court within 7.
No. So let's assume you tell me you don't make your bond. Let's assume in 30 days you haven't made your bond, right? Then you are entitled to that preliminary hearing if you so want it, where the officer will have to show up and then they will have to advise you of what you've been charged with again. And then you'll have a hearing about if there's enough evidence, okay? If you make your bond, you won't have that hearing at all anyhow, okay? So this is only if you don't make it. Now, again, you can still choose if you don't make your bond to still not have the hearing. And what I'm gonna do is I'm gonna send your file on up to the solicitor's office instead of it staying down here in magistrate court. So it moves your case a little quicker if you waive the hearing. But again, it's up to you.
I'll
So,
waive.
okay. So I'm
I'll
gonna put
waive.
down, okay. So I'm gonna put down here, ma'am, that you're choosing to waive the hearing. Based on the information that you've provided in your court-appointed form here, I am gonna go ahead and assign you a court-appointed attorney as well. Do you understand that?
Yes, Your Honor.
All right. Do you have any questions for me, ma'am?
No, sir.
All right. And I think that is all I have for you here this morning, ma'am. Good luck to you.
Thank you.
Thank you. All right. I believe, Deputy, was there also a Simeon Alexander Rogers?
Rogers is a male.
Okay. Oh, I'm sorry. I don't why I had that in. Okay. And then, Deputy, just before we go to the males, I didn't ask them, but because of their situation, Tion DeJeanette, that's being released today. So that's gonna be a waiver because of her release. And then the one behind her, Latanya Nicole Harris, because of her situation, that is also gonna be a waiver because of her release today. So I know I didn't say it on the record, but I want to make sure that I let you know that.
Okay.
And then I think we talked about Ms. Circle, so she knows she needs to sign. Yep. All right.
She's already signed. So do the other two need to sign before they go back?
Yes, sir, they do. That's why I wanted to make sure I told you.
Okay, roger that.
All right, so whenever you're ready, I am ready for the gentleman. I have first up,
Dawkins,
yep, Dawkins, Bilal Dawkins.
Dawkins.
All right, are you Mr. Dawkins?
Yes, sir.
All right, Mr. Dawkins, good morning to you. How are you this morning?
Pretty good about yourself.
I'm doing well, sir. Doing well. You are charged, sir, with 1 count of theft by receiving of stolen property, 1 count of suspended license, and then 1 count of speeding. Do you understand that, sir?
Yes, sir.
Now, the theft by receipt of stolen property carries a bond of $5,000. The suspended license carries a bond of $1,500, and the speeding carries a bond of $2,500. Your total bond is $9,000. Do you understand that?
Yes, sir.
Do you believe you'll be able to make that bond, sir?
I believe so.
Okay. Are you currently working?
Yes, sir.
Based on the information that you provided here on your court appointed, sir, I am going to go ahead and appoint you a lawyer this morning. Do you understand that?
Yes, sir.
And so that lawyer will be in touch with you about your court case as we move forward. Okay.
Yes, sir.
Now, your next court date, since you were charged with felonies here, you got 2 upcoming court dates here that I'm going to give you information about. On August 21st of 2023, you're going to have what is called your preliminary hearing. That's where the evidence will be presented by an officer about your case, and they'll have to determine whether there's enough evidence against you to move forward to the prosecution of it with the DA's office. That's your first court date. Your second court date is going to be August 25th of 2023. That's also going to be via Zoom, and that's also going to be at 8:30 a.m. And that's going to be your bond hearing where they'll review your bond, okay?
Yes, sir.
Do you have any questions about anything, sir?
No, sir.
All right. So again, your bond is $9,000. Your preliminary hearing is $821. Your bond hearing is $825. Both of those will be via Zoom, and I have appointed you a court-appointed lawyer here this morning. You don't have any more questions for me? That's all I have, sir. Good luck to you.
Thank you, Your Honor.
Yes, sir. Next up, I have Jovan Notorio Dupree. All right, good morning. Are you Mr. Dupree? Mr. Dupree, you're charged with 1 count of driving with no license and 1 count of driving with a suspended license. I reviewed your warrant. We are going to go forward on the driving with a suspended license. I've dismissed the driving with no license. And after review of your information, you are going to be released here today, sir. Do you understand that?
Yes, sir.
Now, that does not, let me be clear, that does not mean that your case is over. Your case is going to move forward. It just means that you're going to be out of custody here after today. And so what that means is you want to make sure that once you are released or as you are being released, that the sheriff's office is aware of the best known address to send your information to. Do you understand that?
Yes, sir.
Now, because you are being released, you also will not be entitled to a preliminary hearing. And so what's going to happen before you move up from the podium there, sir, if you would, you're going to sign a piece of paper that's agreeing that you're waiving your preliminary hearing. Do you understand that?
Yes, sir.
All right, sir. So be on the lookout in the mail for that next court date coming up for you. Do you have any questions of me?
Sir, one question. So
Yes, sir.
this is what they call a signature bond?
I'm not suggesting that to you here, sir. I'm just simply saying that you're being released here today.
Okay. No,
All right, but your case is going to move forward. Do you understand that?
yes, sir.
All right, anything else I can answer for you?
Sure.
And I think I advised you, sir, and if I didn't, I'm telling you now, based on the information you provided as well, I am going to appoint you a court-appointed lawyer. So they will be in touch with you regarding your case, okay?
Thank you.
All right, thank you, sir. Good luck to you.
Thank you.
Come on, Freeman.
Next up, I have Mr. Christopher Rashad Freeman. All right, good morning, Mr. Freeman. Mr. Freeman, you are charged with several counts here. The first is failure to register as a sex offender, 1 count of aggravated assault, 1 count of battery, family violence. This is a second allegation, 1 count of terroristic threat, and 1 count of obstruction of an officer. The obstruction of an officer carries a bond of $2,000. As to the other charges, which are all alleged to be felonies, your bond has been denied. I'm telling you that your bond has been denied because I'm showing here that you appear to be on active probation out of the state of North Carolina for a felony. If that turns out to be incorrect, obviously they'll correct that. But from what I'm looking at, it does appear that you are. You know, you don't have to tell me yes or no, don't comment on it, but just I'm letting you know that. Now, as far as your special conditions, the allegations here allege that you were involved in a violent act with someone else. And so your special conditions include for you to stay away from a young female by the name of Victoria Andrade, and that you're also to stay away from the address of 4633 Waldrop Drive. And so let me advise you, if at some point you are given bond, please stay away from her and from that address. If you have items at that address, please contact the sheriff's office, and someone from the sheriff's office, will accompany you to that address to get your items until your case is closed. Do you understand that?
Yes, sir.
Do you have any questions about that, sir?
No, sir.
All right, are you currently working, Mr. Freeman?
No, sir.
Okay, so based on that, I am gonna go ahead and I'm gonna appoint you a court-appointed lawyer. Do you understand that?
Yes, sir.
And so what that means is, you know, they'll be charged free of charge for you to help you on your case and help you defend it to the best of their ability alongside you. Do you understand that?
Yes, sir.
All right. Do you have any questions for me at this point?
Yes, sir.
All right. Whenever you're ready, go ahead.
Who do I get in contact about with being on probation in North Carolina? Because I'm not on probation in North Carolina. That's not me.
Okay. And so, you know, what I would tell you is to speak with your attorney when you get a court-appointed a lawyer. Again, just from what I'm looking at, I could be mistaken, but you know, based on what I'm showing on your criminal history, that's correct. But my advice to you would be, when you get appointed your lawyer, the lawyer will contact you here in the jail, and just tell him, hey, that's something that you want him to check on just to make sure that that's correct. Because if it is incorrect, of course, that needs to be corrected at that bond hearing that you'll have. Okay.
Yes, sir.
Any other questions I can answer for you, sir?
No, sir.
All right, so again, the 21st will be the prelim, 25th will be your bond hearing. You have been denied bond here this morning based on my review of it. However, you are going to get a court-appointed attorney that will assist you moving forward on your case. If you don't have any other questions for me, that's all I have, sir, and good luck to you. All right, next up, I have, I believe is this Mr. Garcia Jimenez? Oh,
No,
Mr. Hackett?
this is Hackett.
Yeah, okay. Give me 1 second. Good morning, Mr. Hackett. How are you?
Good.
Mr.
We don't have a Jimenez on our order, on our
Okay,
side.
so I wasn't sure if he made bond or not because I only got part of his paperwork, so that may be the case. So are you, I believe, is it Mr. Krishan Hackett?
Yes, yes, sir.
Okay, so Mr. Hackett, you're charged with 1 count of DUI, alcohol less safe, 1 count of possession of marijuana, less than an ounce, possession of drug-related objects, and open container. The DUI carries a bond of $5,000, the marijuana $1,000, the possession of drug-related objects is $500, and the open container is $500. So you have a total bond of $7,000. Do you understand that?
Yes, sir.
Now, these are all misdemeanor counts. And I'm telling you that that's important because you have a right to what is called a preliminary hearing. A preliminary hearing is where the officer has to come in and he has to tell the court, the judge, all the evidence they have against you, and the judge will decide if there's enough evidence for your case to continue or they dismiss it. But you only get that hearing if you're still in custody. If you bond out, you lose it, okay? Now, if you know you may not make your bond, there are some people who say, Judge, I want that hearing. And there's some people who say, Judge, just waive that hearing. And the reason they want to waive it is it makes their case move faster because I send it right to the prosecutor. Now, so my first question to you is, do you believe you're going to make bond?
Yes, sir.
Okay. My second question to you is, if you don't make bond, do you want to have that hearing or do you want to waive it?
I already have the hearing.
Okay.
I think I'm gonna get bonded though. Not somebody
Okay.
tell me to get bonded.
But if you don't, I understand. But if
I
you
can
don't,
bond myself.
sir, you can. Yes, sir. You sure can. But what I'm going to do here is I'm going to go ahead and set that prelim date for you. So for some reason you don't end up making the bond, it's already set down for you, okay? Now, that prelim date for you, because you are charged with misdemeanors, is going to be August 22nd, 2023. And that's going to be at 8:30 a.m. And they're going to do that via Zoom. Do you understand that?
Yes, sir.
So do you have any questions of me right now, sir?
No, not at all.
So the last thing I will tell you, I looked over here at the information you provided. Based on your financial state, you're going to have to hire your own attorney. So I cannot appoint one for you. Do you understand that?
Understood.
All right, so again, your total bond, I believe we have here, was $7,000. You did not waive your hearing, so if you don't make bond, your prelim is going to be on 8/22 at 8:30 a.m. via Zoom. You do not qualify for a court-appointed attorney. If you don't have any other questions from me, sir, that's all I have for you. Good luck to you.
All right, thank you.
I believe next up should be Mr. Ernest Nathaniel Harris.
Yes, sir.
All right, good morning, Mr. Harris.
Morning.
Mr. Harris, you're charged with 1 count of criminal trespass and 1 count of disorderly conduct. You do have a condition on your bond, which is to stay away from 6801 Mount Zion Boulevard, a quick trip here in Clayton County. Do you understand that?
Yes, sir.
Now, in looking at your information here, sir, you are going to be released today. Do you understand that?
Yes, sir.
So as soon as you are processed out, they're going to go ahead and release you. That doesn't mean your case is over. It just means you won't be in custody. Do you understand that?
Yes, sir, I do.
Now, you are charged with misdemeanors, but because you are being released today, you will not have a right to your preliminary hearing. So before you leave up at that podium, sir, there's going to be a document for you to sign advising that you are waiving that preliminary hearing. Do you understand?
Yes, sir.
And then lastly, I understand that you are not working. And so we are going to appoint you a court-appointed lawyer. Do you understand that?
Yes, sir.
All right, sir. Well, if you don't have any other questions for me, I believe that's all I have for you, okay?
All right, thank you, sir.
All right, good luck to you, sir.
Thank you.
Thank you. All right, next up should be, I believe this is Tyree Horn. Are you Mr. Horn?
Yes, sir.
All right, Mr. Horn, you're charged with 1 count of loitering or prowling and 3 counts of criminal trespass. The loitering or prowling carries a bond of $1,000 and each criminal trespass carries a bond of $1,500. So your total bond, sir, is $5,500. You do also have a special condition, and that special condition is to stay away from where this was alleged to have happened at 4 Daniel Drive and at 6 Daniel Drive. Do you understand that?
Yes, sir.
Now, you are charged with misdemeanors here. And because you are charged with misdemeanors, that means you are entitled to what is called a preliminary hearing. Based on what I've told you, the $4,500, do you believe you're going to make bond, sir?
Say it again?
Do you believe you're going to make bond on the $4,500?
To be honest, I don't know.
Okay. Now, as I was mentioning to you, it looks like you're not working right now. So I am going to appoint a court-appointed attorney for you. But also, and more importantly, as I mentioned, you do have a right to what's called a preliminary hearing. A preliminary hearing, if you don't make your bond, is where they have to come in, the police officer does, and the police officer has to tell the court what evidence they have against you. All right. So if they have enough evidence against you, then the court will look at it and determine if your case is going to go forward. Now, the alternative is you could say, I don't want that hearing, Judge. Some people who are still in custody will say, I want my hearing. Some people will say, I don't want my hearing. And the reason they do that is because if you don't have that hearing and you're still in custody, your case does move a little faster in resolution because it gets to the prosecutor a little quicker. So my next question to you, Mr. Horn, is would you like to waive your preliminary hearing or would you like to have it?
I'd like to have you.
All right. So because you are charged with all misdemeanors, your preliminary hearing will be August 22nd of 2023. It's going to be at 8:30 a.m. and that's going to be via Zoom. Do you understand that?
Yep.
Okay, give me 1 second here. Let me write that down. So again, Mr. Horn, you have chosen to have your preliminary hearing. So if you don't make bond, your next court date will be the 22nd of August. I have appointed you a court-appointed attorney who will be there with you. That prelim will be at 8:30 a.m. That'll be via Zoom. Your total bond is $5,500 and you are to stay away from 4 Daniel Drive and 6 Daniel Drive. If you don't have any other questions for me, sir, I believe that's all I have for you. Good luck to you. All right, next up is, I believe, Pedro, is it Hewitt?
Yes, sir.
All right, good morning, sir.
How you doing?
Mr. Hewitt, you're charged with 1 count of theft by receipt of stolen property. Your bond is in the amount of $8,000. Do you understand that?
Yes, sir.
Do you believe you're going to be able to make bond, sir?
I think so.
Okay, are you working right now?
No, sir.
Okay. So based on that, sir, I am going to go ahead and appoint you a court-appointed attorney. Do you understand that?
Yes, sir.
All right. Now, you are charged with one felony, so that means you are required, if you don't make bond, to have a preliminary hearing. Your preliminary hearing is going to be August 21st of 2023 at 8:30 a.m. via Zoom. Do you understand that?
Yes, sir.
Then your bond hearing is also going to be 8/25/2023 at 8:30 a.m. as well, so 4 days later. Do you understand that?
Yes, sir.
All right, so again, your current bond is $8,000. Your next court dates will be 8/21 and 8/25 for your prelim and then for your bond hearing. And I have appointed you a court-appointed attorney that will be there to assist you in your case. Do you understand all that I've told you this morning?
Yes, sir.
All right, sir. Well, if you don't have any other questions for me, I believe that's all I have for you. Good luck to you.
Follow them.
Next up should be Stephen, I believe Kisaka. Are you Mr. Kisaka?
Yes, sir.
Mr. Kisaka, you're charged with one count of simple assault, one count of criminal trespass, and one count of obstruction of an officer. The simple assault carries a bond of $2,000, the obstruction $2,000, and the criminal trespass a bond of $1,500 for a total bond of $5,500. Do you understand?
Mhm. Yes, sir.
You also have special conditions. Your first is to stay away from the alleged victim, Donald Mwasai, and also to stay away from the address of 7116 Babbling Brook Drive. As I mentioned earlier, if that's where you live and you make your bond, Mr. Kasaka, please contact the sheriff's office here in Clayton County, and they will go with you to that address to get your items until such time as you resolve your case. Do you understand?
Mhm.
Yes, it's got to be yes, sir. Okay.
Yes.
Now, you are charged with all misdemeanors here. What that means is, if for some reason you don't make bond, you have a right to what is called a preliminary hearing. And what that preliminary hearing does is that's where the officer's got to come in and he's got to present all of the information that he has that he arrested you with to the judge, and the judge makes a decision about if there's enough evidence for your case to go forward. Now, if you make your bond, you won't have the hearing, you waive the hearing. Now, if you don't make bond, there are some people who choose to have it and some people who say, Judge, I don't want that hearing because it does slow their case down a little bit. So my question to you is, one, do you think you're going to make your bond?
Yes.
My second question to you is, two, if you don't for some reason, do you want to have your preliminary hearing or do you want to waive it?
Well, I mean, what speeds it up? What speeds up my case?
A waiver of the hearing, sorry.
Okay, I guess waiving it, I guess.
Okay. So I'm going to go ahead and put down that you waived your hearing if in fact you don't make bond. I've also recorded that you do believe you're going to make your bond, however. Now, I've looked at your financial information here, and based on what you provided, sir, you do not qualify for a court-appointed attorney. So that means whether you make your bond or not, you will have to obtain your own attorney. Do you understand that?
I don't have a job or anything.
That's not what you put here.
No.
You put in here that you got some pretty decent assets. Well, how much do you have any money in a bank account?
No.
Okay, so maybe that was incorrect, what you wrote there. So you said you're not working, is that correct, sir?
I'm not working, no.
Okay. So I'll go ahead and appoint you a court-appointed attorney then, based on that, what you just represented to me. And then they will be in touch with you and speak to you about your case. Do you understand that?
Yes.
All right, so again, your bond is in the amount of $5,500. You're to stay away from Mr. Mwasai and 7116 Babbling Brook. You have waived your preliminary hearing, and I have appointed you a court-appointed attorney this morning. Do you understand?
Okay, yes.
All right, sir, unless you have any other questions for me, I believe that's all I have. Good luck to you. I should have Mr. Joshua Wayne Lott.
Yes, sir.
Are you Mr. Lott?
Yes, sir.
Mr. Lott, you're charged with one count of public drunk. Based on a review of this information this morning, sir, you are going to be released this morning. Now, please understand that does not mean that your case is ending here this morning. Do you understand?
Yes, sir.
So whatever last known address you have with the sheriff's office, make sure that's still a good address so they know where to send your mail for your next court date. Do you understand?
Yes, sir.
Now, because you're being released, you will not have a right to a preliminary hearing. So the deputy is probably having you sign a document right now where you are waiving your right to that hearing
Yes,
because
ma'am.
you're being released this morning. I see here that you are currently working. How much are you making per month? So not very much.
Poquito,
You said, is that right?
a little
Okay,
bit.
very little. Okay. So because of that, sir, I am going to go ahead and appoint you a court-appointed attorney. So that attorney will be in touch with you about your case moving forward. Do you understand that?
Thank you, Jan.
All right. So again, you will be released today. You are being given a court-appointed attorney, and you have chosen to waive your hearing because you are going to be released. Any questions of me, sir?
No, sir. Thank you.
All right, thank you. I believe that's all I have for you. Good luck to you. All right, next up, I believe should be Mr. Avery Perry. Are you Mr. Perry?
Yes, sir.
Good morning, Mr. Perry. How are you?
Good morning. I'm good.
Mr. Perry, you are charged with 1 count of simple assault, family violence, and 1 count of criminal trespass. Do you understand that?
Yeah.
The simple assault carries a bond of $3,000. The criminal trespass carries a bond of $1,500 for a total bond of $4,500. You do have special conditions, and that's to stay away from Cassandra Perry and also from the address of 1204 Fairway Point Drive. So if that's your address, sir, where you live, I would advise you that if in fact you do make your bond, that you speak with the sheriff's office, and the sheriff's office will go down there with you and help you get any items that you need until your case ends. Do you understand that?
Yes.
So you are not to go onto that property unless this bond is modified, allowing you to do so without the sheriff. Again, do you understand?
Yes, sir.
Now, let me tell you, I am going to appoint you a court-appointed lawyer this morning based on what you've provided as your income. The last thing I have to ask you is, because you are charged with misdemeanors, if for some reason you don't make your bond, you have a right to what is called a preliminary hearing. And what that means is you can have this hearing, the officer's got to come in, they've got to show the judge all the evidence they have against you, and your case will either be moved forward or dismissed. However, if you make your bond, you lose the right to that hearing. But if you don't make it, and you might say, Judge, I don't want that hearing after all anyway, and I'll tell you, some people choose not to have it because it can make your case go a little faster. So my question to you is, do you want to have your preliminary hearing, or do you want to waive it if you don't make your bond?
Yeah, let me waive it.
Okay. All right. So I'm recording here this morning, sir, that you have chosen to waive your preliminary hearing. I have advised you in review that you will have a court-appointed attorney. Your total bond is $4,500, and you do have special conditions, which are to stay away from Ms. Perry and from that address where this is alleged to have happened. Do you have any questions for me, Mr. Perry? Sir?
No, sir, I have no question.
All right, sir. Well, then that's all I have for you. Good luck to you. I believe next up should be Mr. Simeon Rogers. Are you Mr. Rogers?
The door.
Mr. Rogers, you're charged with 1 count of entering auto, 1 count of theft by taking of a motor vehicle, 1 count of loitering or prowling, and 1 count of criminal trespass. I have dismissed the count of criminal trespass. However, the 1 count of entering auto and the 1 count of theft by taking, your bond has been denied pursuant to statute 17-10-1, because according to my review of your criminal history, you are currently on probation, felony probation out of DeKalb County. Do you understand that? Do you understand that, Mr. Rogers? Is that a yes?
You have to speak yes or no. Yes, sir.
Okay. Now, because you are charged with a felony, you do have a right to a preliminary hearing. So your preliminary hearing, sir, is going to be August 21st of this year at 8:30 a.m. via Zoom. Your bond hearing is going to be August 25th of this year at 8:30 a.m. via Zoom as well. Are you working right now, Mr. Rogers?
I just recently applied for a job in downtown Decatur.
Okay, so before that, you were not working?
At home with my family.
Okay, so based on that, sir, I am going to go ahead and appoint you a court-appointed lawyer this morning. And so they will be in contact with you to discuss your case moving forward. You understand that? Okay, so again, your upcoming court dates, the 21st and 25th of August for your preliminary hearing and bond hearing. Your bond is currently denied because you're currently on probation out of the cab. And your attorney will be in touch. So good luck to you.
Thank you.
Head
All
on
right,
back.
next up I have Alejandro, I believe this is Turabiatis. Is that
Yeah.
you, Mr. Alejandro?
Gracias. Yeah, that's me, Your Honor.
Okay, so Mr. Alejandro, you're charged with one count of reckless driving, one count of no insurance, one count of expired tag, one count of concealing an ID of a motor vehicle, and improper use of a dealer's tag. Your total bond is in the amount of $4,500. Do you understand that?
Yes, sir.
Do you believe you're going to be able to make your bond, sir?
Yes, I'll be able to pay that right today, right now.
Okay. And are you working right now?
Yes, I'm a diesel technician. I work on trucks.
Okay. How much are you making per month?
Make 720 a week, so like 2,800 a month.
Okay. So based on that, sir, I am not going to be able to appoint you a court-appointed lawyer this morning. So if you would like to have a lawyer in your case, you're going to have to hire your own. Do you understand that?
Yes, Your Honor.
Now, the next thing is you're charged with all misdemeanors. So if you make your bond, you don't have to worry about this. But if for some reason you weren't to make your bond, you have a right to what is called a preliminary hearing. A preliminary hearing is where, again, if you don't make your bond in 30 days, the police officer has to come to court and he's got to tell the judge all the evidence he has against you. And the judge will determine if there's enough for your case to keep going or he'll dismiss it. Now, if you don't make your bond, like I said, you can have that hearing or you can waive it. And I'll tell you, some people do choose to waive it because it makes their case move along faster if they don't have it. So my question to you is, do you want to have the hearing if you don't make your bond, or do you want to waive it?
No, I can pay that bond today.
All right, and I understand that, but if in fact you for some reason couldn't make the bond, do you want your preliminary hearing or do you want to waive it?
I would wait.
You would waive it? Okay. All right, so the deputy there is going to hand you a pen and a piece of paper. He's going to have you sign. And again, this is only if you do not make your bond. Again,
Yes.
okay, and again, your bond is $4,500. I'm putting here that you have waived your preliminary hearing and that you're going to be hiring your own attorney. If you don't have any questions for me, sir, we're done and you're good to go.
I appreciate you.
All right, thank you. All right, I guess that leaves us with Mr. Hector.
Yes, sir. That is right.
All right, so if you give me a few moments here, I'm going to call and see if we can get an interpreter on the line.
All right. Hey, Judge.
Yes, sir.
Hey, we have I don't know if we can do it or not, but we have a inmate here that said he would interpret for us. I don't know if we
Yeah,
can.
I can't. I got to have someone official that has to be sworn in.
Okay. Okay.
Yep, give me 1 second.
Yes, sir.
by the name of Hector Vasquez that needs assistance in interpretation in Spanish, okay?
Okay.
All right, so I have them on the line, so whenever you're ready, if you just want to introduce, well, I'm sorry, first of all, Mr. Interpreter, if you would, can you please raise your right hand? Do you swear or affirm that the interpretation that you're about to give will be truthfully and fairly interpreted, so help you God?
Yes.
All right, sir, so if you want to go ahead and introduce yourself to Mr. Hector Vasquez.
Okay. No soy inglés.
Yo seré su intérprete hoy.
Okay.
All right, he said, okay. So Mr. Interpreter, if you would, please advise Mr. Vasquez that he is charged with 1 count of public drunk. Mr. Interpreter, oh,
Cargando como intoxamiento por estar ebrio, bebiendo en público.
he's also charged with 1 count of obstruction of an officer. Okay. Now tell Mr. Vasquez that because I have taken a look at his history, he is going to be released here today.
Porque han mirado su historia, lo van a dejar ir hoy.
I don't think he understood, Mr. Interpreter. If you could tell him one more time.
Como han revisado su historial policial, lo van a dejar ir.
Ay, ¿y qué más? Ahorita que venga a traer mi papeles el otro señor ahorita, es que pues, me explique bien. Él sabe, pues aquí todo. Sí, está bien, ahorita que venga el señor que también le gané. Es que no, es que no entiendo bien. Ahorita voy a tener mis papeles.
Fire.
He said he has some papers.
Escucha. Okay, sí.
¿Papeles de qué anteriormente?
De teniente coronel que va a traer, que ahorita te viene.
All right. Can you? I've got it all the way up. How about this? Can you just advise him, Mr. Interpreter, that if he has any paperwork that he brought with him to the court, to the jail, they will return that to him when he's released later today.
Si tiene algunos papeles que ustedes le tomaron cuando lo arrestaron, ellos se los darán cuando lo suelten hoy.
Okay, Mr. Vasquez?
No escuché bien.
Can you repeat that again, Mr. Interpreter?
El papeleo que usted haya tenido cuando entró se lo devolverán al salir hoy.
No, ahorita que venga el señor, ahorita les vamos a hablar de eso. La señora ahí donde que me comenta que me dijo que yo me había robado algo ahí, unas cosas de su casa, pero yo no robé nada. Sí, pero yo no sé, ahorita que venga acá, vamos a hablar ahorita. Con está.
He's talking about someone that said he stole something, that he didn't steal anything.
Okay. Well, please tell him, Mr. Vasquez, that has nothing to do with today's case. As for today, you will be released on your current charges.
Eso no tiene nada que ver con el caso pendiente hoy. Por lo de hoy lo van a soltar.
Mr. Vasquez, did you hear that?
Lo van a dejar ir. Eso no tiene nada que ver con este caso.
No, ahorita que venga, ahorita voy a hacer otra cosa para acá.
Sí.
Sí, ok. Pero no. Tiene que ver otra cosa aquí.
Deputy, hold on, Mr. Vasquez, hold on.
Uh-huh.
Deputy, if you would have him sign a waiver. I think he understands that he's going to be released here today.
He does, Your Honor.
Okay. All right, Mr. Interpreter, that's all we have for you today.
No,
All right, thank you. Bye-bye. Hold on, Mr. Vasquez.
Say again, say again. Sí.
Quiere que firme aquí, pero no sé.
I've disconnected with them.
He's not wanting to sign, Your Honor.
Sí, pues así de todo se juega, pues.
Okay, that's no problem. Just put on the document, refuse to sign.
Okay.
All right, and I believe that's everybody. So once I get that one, I'll send over everything.
Okay.
Okay, Your Honor.
Tómale firma, entonces, si no te-
All right, thank you, Deputy.
Ah.
Have a good day, Your Honor.
Same to you, sir. Bye-bye.